General Introduction to Discovery When You're Sued for Debt, Part 2. Brought to you by Kenneth Chabert at yourlegallagout.com. Your advantage if you're being sued by debt collectors. You have an obligation to make reasonable efforts to find out the answer if it's something you should know but the other side doesn't. Say what? For example, they'll probably ask you if a credit card statement, is correct. Looking at it attached to their interrogatories, you simply can't know if it's true. How would you? Did you memorize the statement? Yes, it looks like yours, and it may have your name on it. But how can you know that you received it? How can you know that they haven't tampered with it? Debt collection agencies do all sorts of dirty tricks, really. And they do sometimes make up statements that look like consumer statements. So how can you know? Well, you might know if you have a copy of the statement in a drawer downstairs. I always used to suggest to my clients that they not keep such records back when I was practicing, but if you do, and you get an interrogatory that you could answer by walking downstairs, you are supposed to do that. When I was a lawyer, I'd tell my clients that they had to do that. I don't have to say that now. Now I can say that if you don't do that, or if you forget about those records, no one will likely ever find out. But under the rules, you're supposed to check them. What if the information was lost in a flood, but you might be able to get it by asking your bank to reconstruct them? Or maybe you could ask your ex-wife, or something extreme like that. Would that be reasonable? You only have to do it if it is. I can't tell you what reasonable is, but I never required my clients to dig up an ex-spouse and ask. I can tell you that. You'll have to decide. And then in your answer you say, I don't know, or whatever you choose to say. Or if they try to get you to do something extreme, you might object as unreasonable or oppressive or unduly burdensome. Remember, the debt collectors will be happy to make you dig till doomsday, and they'd be thrilled if you fished them up some of the evidence that they don't have, or give them something that would embarrass you. Do I have to tell you that you probably don't want to do that? Your objections to requests for production will probably be the same generally as to interrogatories, except that you're not swearing to the documents, of course. You are responding to the request, will provide, object, or do not have, or you might say none exist. If they did exist, but you no longer have them, the rules say that you have to, if you know, say what became of them. You only have to get documents that are in your possession or control, according to the rules. So again, no ex-spouse is necessary, probably. Use your own judgment there. Alright, regarding your discovery on them, I will be doing most of the talking about that in the specific videos on particular kinds of discovery. In general, though, remember that you will be serving discovery on the other side and probably only a notice of discovery on the court. Look at my video on serving versus filing if you've not already done so. And I will repeat the importance of filing discovery on them before they do on you. You'll notice that there are time requirements for the responses. You want to serve discovery on the other side, if possible, so that they have to answer before you do. And ideally, even before they get around to serving discovery on you, although this is normally too much to ask, or even hope for. But why is all this so important? Two main reasons. First, the sooner you serve discovery on them, the more of a drag you are to them. They might give up, although they probably won't. Instead, they'll probably file a bunch of bogus objections. I want you to see the way they answer the discovery you give them before you try to answer theirs to you. You'll be lucky to get anything at all that isn't a bogus objection. So you'll see better how the game is played, and you can get your motion to compel started sooner than they can. You want to push things at the discovery phase so that you're a big drag to them. The second main reason for getting your discovery off quickly is that it sends a message to the court, too. They like to get rid of these cases extremely quickly if they can and with a minimum of fuss. If you have served discovery, the court must take you seriously when you say the trial can't be for another 6 months because you have to follow up on it. If you haven't served discovery and you ask for a trial date that far out, they'll often tell you that it has to be sooner. Whatever the court says, and whatever the date set for trial, when the debt collector comes back with the bogus objections, you can file a motion to compel. Whatever the court does after that, you might ask for the trial to be set back a little bit longer. You've set it up for that. And you might or you might not want to do that. But you've set it up by getting right on the discovery. And you can place the blame for any delay on the other side. Next up is specific types of discovery. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice. But I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms, and defend yourself from the debt collectors.